Good morning, everyone. Welcome to Linda Liu IP Court. My name is Erica Lee, and I'm a trademark attorney in the trademark department. Today, I would like to share some experience on handling trademark refusals against the Chinese extension of international registrations under the Madrid Protocol. And I will focus on the rejected goods and services. When receiving a notification of refusal for international registration, there are usually two refusal grounds regarding the designated goods or services. One is the prior identical or similar trademarks on identical or similar goods or services, and the other is unacceptable goods or services in China. First, let's talk about prior trademarks. Indeed, when the registrant receives a notification of refusal due to the prior trademarks, the registrant may first consider how to remove the earlier obstacles, such as checking whether the earlier trademarks are still valid or submitting non-use cancellations, oppositions, invalidations, etc. against the prior trademarks. However, when the prior obstacles cannot be eliminated and the rejected goods of international registration are different from those of the earlier trademarks, what other remedies can be taken? In fact, the registrant may consider filing a request with the WIPO to limit the rejected goods or services to those which are not similar to the designated goods or services of the earlier trademarks, and at the same time to file a review of refusal to the CNIPA for a trial. Before diving into this action, let's get some background of the China's trademark classification of goods and services. In principle, China adheres to the NIS classification system. The Chinese classification further divides each international class into several subclasses based on the similarities of goods and services in functions, raw materials, intended use, contents, modes, objects, etc. Some subclasses are further divided into different groups and paragraphs. Generally speaking, goods and services in the same subclass are deemed similar, unless otherwise specified in the Chinese classification. When the international registration are extended to China, the examiners of the CNIPA will translate the specifications of the international registrations into Chinese and assign the subclasses for the designated goods and services. Since the designated goods of an international registration need to be consistent with those of the basic application or registration, the descriptions of the designated goods and services are sometimes too broad, or the item of goods may contain several different goods. Therefore, there may be a situation where one item of goods or services of the international registration can be divided into multiple subclasses. If the designated goods of the earlier trademark only block the goods of the international registration in some of the subclasses, the registrant can limit the good to those of the dissimilar subclasses. For example, in Class 8, the goods hand-tools, hand-operated is divided into subclasses OA01 to OA10. If the prior trademark only blocked the international registration in subclass OA01, and the goods in this subclass are not the registrant's main products, the registrant could limit the goods hand-tools, hand-operated to some specific goods listed in the subclasses OA02 to OA10 to overcome the obstacles. However, it should be noted that the goods and services after limitation cannot exceed the scope of original ones. Next, let's focus on another reason of refusal: non-acceptable goods and services. Generally, the CNIPA will reject the goods or services since the goods or services per se is not acceptable. The CNIPA generally does not accept descriptions for wholesale or retail services, except those for pharmaceutical, veterinary, and sanitary preparation and medical supplies. The description of goods or services is unclear or too broad, such as real estate affairs. The business of goods and services are illegal in China, such as the goods and services related to marijuana or gambling or gaming services. If the registrant is engaged in legal business of the goods and services under the same subclass, the registrant can limit the goods and services to the acceptable ones to protect its legal interest. In light of the above, in the event of a trademark refusal caused by the designated goods and services, if there is no other remedy, the registrant can try to file a limitation of goods and services with the WIPO and file the review on trademark refusal with the CNIPA at the same time, in order to obtain the protection of international registration in China, at least on part of the designated goods and services. Thank you for your listening today. If you have any other inquiries or requirements, please feel free to contact us. Bye.